People that have wealth above the, in the 8 figures, you're probably fine. You are fine with an estate planning lawyer with tax expertise. The majority of us, though, are people that are concerned about long-term care costs, concerned about spending money that's actually going to deplete their estate. And that's where elder law comes in. You see, an estate planning lawyer can prepare for you documents, but what they're not going to be thinking about, that an elder law attorney is going to be thinking about, is what happens if you're married, during your lifetime, you or your spouse need expensive long-term care. You need to be maybe at a memory care. You need to be at a skilled nursing. There's Alzheimer's diagnosis, and that person might need 10 years of memory care. That's a lot of money. That's likely over $1 million. What's going to happen? An estate planning lawyer is not going to be able to help you with that. An elder law attorney is, yes, an estate planning lawyer, but we also have knowledge of government benefits and how to protect assets so that government benefits, including the state paying for care, can happen. So the question, one of the questions in the chat here was, how do you protect assets when you're in that situation? Maybe you and your spouse have $1 million. You own a house that's worth $500,000 and you've got $500,000 in investable assets, and one of the spouses needs to go into memory care. Without having an elder law attorney, having prepared your estate planning documents, have the right durable powers and attorney in place, have the right will with asset protection in place, that couple may very well end up having enough money to pay for the first spouse's care, but the survivor is left with nothing. And that is really unfortunate when that happens. It happens way too frequently. This is what an elder law attorney would do. That couple comes to us, we have an Alzheimer's diagnosis for one, but they're not far enough gone that they don't understand their estate planning. Remember we had talked a little bit earlier about people being too young for an estate plan? Sometimes people can wait too late. Don't let that be you. Even if there's an Alzheimer's diagnosis, that doesn't mean the person doesn't understand, but don't wait too long, because as an attorney, the person needs to understand their estate plan. And if they don't understand anything, our hands are pretty much tied with how we can help them. But we still can work with people with diminished capacity. Elder law attorneys do that all the time. We can still get a good plan in place. So we get the right estate plan in place, one that allows us to transfer all assets to the well spouse. That's usually done through some sort of property status agreement. And we transfer the house into the name of the well spouse. We transfer all the bank accounts into the name of the well spouse. And then once the care situation is determined for the ill spouse with Alzheimer's, then we can apply for Medicaid. And you might be saying, well, how does that work? I can tell you that when we're looking at Medicaid, when we're looking at memory care, most facilities with memory care will require 2 years of private pay. So it's not like we couldn't do the Medicaid qualification even with that asset level. We are more constrained because the care facility that's appropriate for the person with Alzheimer's requires 2, if not 3 years of private pay. What's paramount is the quality of care for the person who needs care. Medicaid is secondary to that, at least in my opinion. So maybe this couple does need to pay for the 2 years of private pay because they needed that facility to then say, okay, you paid for care here 2 years, now we'll accept Medicaid. So during that time frame, they spent down $100,000, $200,000. That's simply how it works. Can I qualify for that couple now? Let's say the wife has been in memory care for 2 years. Memory care will accept Medicaid. Husband now has $300,000 in the bank and the house. Yes, I can qualify that ill spouse for Medicaid. How do I do that? Medicaid in this situation says that the couple can only keep about 60,000 in countable assets. I said I had 300, got $240,000 too much. What am I going to do? Probably use a Medicaid compliant annuity. We've got other webinars on this, but a Medicaid compliant annuity is allowed by the state and allows you to take countable money and make it non-countable by putting it into annuity. And that annuity is accepted by the state. Wife goes on Medicaid, state pays for the care, husband gets to keep all of those assets. State has no recovery on that, assuming that the husband lives out the term of the annuity, which here in Washington is typically a 5-year. So I hope that answered the question about what do you do if there's long-term care costs, and does a couple have to spend down all their money? No, they don't. Why not? Because they're working with an elder law attorney that knows Medicaid's rules, and we know how to protect the assets. So that's where I was, talking about estate planning done by the correct professional. The correct professional, if anybody is concerned about the finances, the costs of long-term care, is going to be the correct professional is somebody that understands elder law, understands Medicaid qualification, understands the rules to protect assets. Who is concerned about long-term care costs? Well, certainly not anybody that's younger usually, but if somebody is retired, we all know that as we age, care becomes more likely. Statistically, if you look on the internet as to what the chances about care are, if you are 65 or over, there's a 70% chance you are going to need long-term care. And that long-term care can be, just care at home, which usually the family members provide, or it could be at a nursing facility. And according to longtermcare.gov, 35% of people who are over the age of 65 will require 1 year of care in a skilled nursing facility. Well, that's about $12,000 a month times 12. That's $144. That's almost $150,000 a year. $150,000. And with an estate plan that has the elder law expertise incorporated into it, especially in skilled nursing care, I'm not talking memory care. Skilled nursing care typically does not have a private pay requirement. So typically we can preserve all of the assets for that couple, not just a portion of them.